Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We have been following the appellate matter proceeding in the state of Indiana, known as Richard Allen versus State of Indiana, commonly referred to as the DelphI case, dealing with very tragic events in Indiana concerning two young friends, Abby and Libby. Mr. Allen was convicted of their unalivings in 2024. He filed an appellate brief in December of 2025, as we previously reported to you, citing errors principally based on the Fourth Amendment, illegal searches and seizures, looking for a new trial. In the alternative, he felt that the trial court, Judge Gull, committed error by not providing him with a Franks hearing, which challenged the warrant affidavit. If this case is ultimately reversed for a new trial or for a Franks hearing, it appears more likely than not that Judge Gull will not be presiding over it because she has filed a notice of intent to retire from the bench at the end of this year. State of Indiana filed papers in the appellate court, number one, seeking an extension of time to file their response in opposition to the appellate brief, and in encouraging what we will believe strongly for the appellate court to not disturb the events occurring in the court below, the trial court. They also filed a motion to submit an oversized document, a response that would be larger than what the appellate rules require or allow. The motion for permission to file oversized brief states that Allen is directly appealing his convictions and sentence for 2 counts of unaliving. He filed his brief of appellant on December 17th, 2025, and consistent with Appellate Rule 44B, this motion is being filed at least 15 days before the state's brief will be due to be filed. Although the state's brief is currently due to be filed on January 16th, 2026. Contemporaneously with this motion, the state is also filing a motion for extension of time, requesting to be given until March 17th, 2026, in which to file its brief. The state points out that the appellant, Mr. Allen, was granted permission to file an oversized brief of 24,000 words, and that Mr. Allen's brief is 113 pages long and raises, by the state's count, 13 different issues, many of which contain multiple grounds upon which error is asserted. The state of Indiana says the case also has an extremely lengthy record, including a 22-volume transcript, 15 volumes of electronic exhibits, and 2 volumes of conventional exhibits. There is a considerable amount of evidence to summarize and relay in the brief. Bottom line, the state requests permission to file an oversized brief of no more than 24,000 words, which is the same size as the appellant, that would be Mr. Allen, ladies and gentlemen, was given. And looking on the court docket, the court has granted these motions. The state is now authorized to file an oversized brief of up to 24,000 words, and this is per a court order that was filed January 16th, 2025, right there on the docket for you to review. And there's a second order that granted the state through February 16th, 2026, to file their response in opposition to what Mr. Allen stated in his initial brief on the merits. We will continue to monitor this situation As further developments arise, until next time, this is Kathy. Thank you for joining us here today.